Good day and welcome to this week's edition of It's Chaile Time. We will be looking at a case law review this week, a summary or case study from the Constitutional Court between NUMSA and Trendstar. And for those of you, if this does not ring a bell, it deals with the legal question of whether an employer can use replacement labor in terms of a lockout that is in a response to strike action. It's called a defensive lockout. Because in terms of Section 76(1)(b) of the Labour Relations Act, if a lockout is called in a response to a strike, then indeed an employer can use replacement labor. But it seems there are some technicalities in the way it's been applied or the way the Constitutional Court argued this case. So, for those of you who may not necessarily know, in the process of collective bargaining, the ultimate weapon for a employee party or the union is strike action, to try to strong arm or compel an employer to accept a demand. Now, this demand is typically in terms of a matter of mutual interest, maybe a benefit or the creation of a benefit or increase in wages and so forth. But the employer also has a very similar weapon. It's almost like a strike for employers, but it's called a lockout. Now, basically an employer, in terms of a matter of mutual interest, maybe the employer also has to have a demand and they want to compel or strong arm the employees to accept the demand. And if the employees refuse, so the employer can go on a strike, if you want to put it that way. But it's called a lockout. So the employer can actually call a lockout. Very similar process to embarking on a protected strike. The process go through the CCMA, a process of conciliation. If you do not settle at conciliation, you give 48 hours notice of either a strike or a lockout. But with the lockout also, the employees will be locked out from providing the labor, and there will typically be no remuneration. But now, normally with a lockout, the employer cannot use replacement labor. So just as there's a bit of a sting to the employees in terms of not providing the labor and not getting paid for it, the employer must also accept some level of pain in that, there's a cease of the operations, the revenue generating operations. But there is an exception to the rule in terms of Section 76(1)(b), whereby if the lockout is called as a response to a strike action, then the RA states that an employer can actually use replacement labor. But this is a contentious issue, especially in this case. Now, in this case, on the 23rd of October 2020, conciliation failed. The union demanded a gratuity bonus. It's not just like a once-off payment to the staff to the value of 7,500 rand. The company Trendstar obviously did not want to do so. So conciliation failed and the union gave 48 hours notice to embark on a strike with total withholding of labor to commence on the 26th of October. And they did for a few weeks, continued with the strike action, but very interesting. On the 20th of November 2020, the union wrote a letter to Trendstar saying they are actually suspending the strike action that at the close of business on that day. Now, close of business was 5 o'clock. So as from 5 o'clock on the 20th, the strike has been suspended, effectively meaning that as from the 23rd of October, I suppose there's a weekend or something in between, all the staff will report back to work. But the union did say that, the fact that they're suspending the strike action does not mean they're ceding the demand for the 7,500 rand gratuity bonus, the once-off payment they demanded. But okay, be it as it may, they are suspending the operations, or suspending their strike. But the employer, in response, before 5 o'clock, before close of business, 5 o'clock on the 20th of November, sent a letter to the union saying, but listen, as on the 23rd, they will be implementing a lockout, and this company will be using replacement labor. And this is now where the contentious issue coming in, because there's two elements to how we interpret Section 76(1)(b) in terms of the company arguing that, first of all, if the union suspended the strike, it doesn't mean the strike is terminated. Okay, so it effectively or semantically, I suppose, the strike is still in effect. And secondly, how do you define or how do you apply the principle of the lockout was in a response to the strike? Because the fact of the matter is, by the 23rd of November, there was practically no more strike. But the letter of lockout was issued during the time when the strike was still in occurrence, albeit before 5 o'clock on the 20th of November. So technically the strike is still in effect, and therefore the lockout lockout notice came out, and on the 23rd of November, the lockout will take effect. So obviously, the union then applied an urgent application at the Labour Court to interdict the company because of their interpretation. They are basically saying that strikes and lockouts, it's about a balance of power in a collective bargaining process. If an employer is allowed to interpret Section 76 to mean that once the strike ceded or was suspended in this case, and they still call a lockout because of the strike that preceded the lockout, it means that the employer can then indefinitely continue with this lockout. It becomes a form of punishment, and it no longer serves the purpose of equilibrium in terms of the power balance between the employer and employees on the other side. Because now, employers can just continue with the lockout, until, and the employees will have no recourse really from that perspective. So they filed application at the Labour Court. They failed at the Labour Court. Basically, the Labour Court interpreted, that the lockout was still in response to a strike. So in terms of this strict technical interpretation of Section 76, it failed at the Labour Court. The Labour Appeal Court on appeal basically found that, because the strike action nor the lockout was still in occurrence at that time, the whole matter is moot. So they appealed to the Constitutional Court. This is NUMSA now. And basically from a constitutional perspective, they are saying that, but listen, this matter deals with the interpretation of the LRA on a constitutional right, the right to strike. But what's quite interesting is the Constitutional Court also alluded to this principle, is that the Constitution in Section 23 basically provides for inter alia a right for employees to go on strike in the collective bargaining process. But interesting is the right to lockout is not a constitutional protected right. It's actually not in Section 23 of the Constitution. So yes, the Constitutional Court basically had to deal with these two elements: suspension of, what does it mean when a strike is suspended? And secondly, when is a lockout in a response to a strike? So I just want to read some of the provisions that was found in the Constitutional Court case. Yes. The Constitutional Court dealt with the suspension issue as follows. I start with the distinction Trendstar draws between a suspended and terminated strike. In order for there to be a strike as defined in the Labour Relations Act, there must be a concerted withholding of labour, and this concerted withholding of labour must be for a specified purpose. Okay? Obviously, because there's a demand in terms of a matter of mutual interest now, okay? So if employees are not refusing to work and are not retarding or obstructing work, they are not on strike and no strike exists. So what they're saying here is, if the employees are not withholding the labor, there's no strike. So in a way, the terminology of suspended strike or terminated strike becomes irrelevant. It's actually not found in law at all, okay? So the issue is, are the staff withholding their labor, yes or no? Okay, so this is the ordinary meaning of the word used in the definition of strike. If the employees were previously refusing to work for a prescribed purpose, but are no longer to refuse work, there is no strike. The fact that a grievance or dispute underlying the prescribed purpose remains in existence does not mean that the strike has not come to an end. A demand unaccompanied by a concerted withdrawal of labour is not a strike. The court continued to argue that the LRA does not deal with the termination of strikes or with suspended strikes, just as I stated now earlier on. This is unsurprising. A strike is a state of affairs occurring with a particular purpose. It either exists or it does not. A strike ends in the sense of no longer existing when there is no longer a concerted withdrawal of labor. So basically, whether NUMSA suspended the strike or terminated the strike is irrelevant. The fact of the matter is, by the 23rd of November, there was no more withholding of labor. So the strike, for all legal purposes, was called off. But now we need to deal with the second issue. How do we interpret then or apply the matter of the lockout was called in a response to the strike? Because the issue here now is, if the lockout was called in a response to a preceding strike, will it still hold in terms of section 76(1)(b? Or are we saying that you cannot call or an employer cannot call a lockout once the withholding of labor is ceded? In other words, for all practical purposes, there's no more strike. So let's see what the court did. Okay. So in terms of the first definition, or possible interpretation of the definition of section 76(1)(b, the expression in response to a strike is capable semantically of the meaning that it could be understood as categorizing a lockout with reference to what caused the lockout to be implemented in the first place. So if there used to be a strike historically, then the strike or the lockout is in response to that strike. Okay, and if that interpretation is accurate, then I suppose you can actually use replacement labor. If the lockout was implemented because the employees went on strike, one could say that the lockout was in response to a strike. Once the cause of the implementation of the lockout is established, its character is fixed and the right to use replacement labor lasts as long as the lockout lasts. So basically, one can say, from a certain point of view, if the lockout is called in response to a strike that occurred historically or preceding the lockout, then an employer can indefinitely implement a lockout and then use replacement labor. Okay, but is that the view that the court will adopt? That's the question. So on this view, it might not even be necessary for the lockout to have started while the strike was still underway. So basically, in this view, even if a strike stopped, the employer can then still call a lockout in terms of this interpretation and use a replacement labor. The question would simply be whether the employer had recourse to use its ultimate weapon because the employees were the first to choose their ultimate weapon. So, but there's a second way of how to interpret this whole situation here. And here we start playing with language in terms of whether the lockout is in a response to the strike. So the present tense is in the expression unless a lockout is in response to a strike lends some support to this approach in terms of that the lockout must be a response for a strike that is currently still on the way. So that's the second interpretation. The lockout can only be called while the strike is still on, not occurred previously. The right to use replacement labor depends on whether, at the time such use is proposed, the employer's exclusion of workers from the workplace is an exclusion which is responding to a strike. This suggests that the strike must still be underway at that relevant time. So basically, the second way to interpret, a lockout is in response to a strike is, the strike must still be in occurrence, and therefore the lockout is a response to the current strike still underway. So particularly since the right to strike is constitutionally protected, that's the right to strike, while the right to a lockout is not, one can understand why our lawmaker in general does not allow an employer to use replacement labor during a lockout. So in terms of section 76(1)(a), once an employer calls a lockout, you cannot, use replacement labor. But in that case, then the lockout will be a form of attack. But in subsection B, just the next provision, if it's a defensive lockout, it says that you can. So if the employer wishes to inflict pain on employees by excluding them from the workplace and not paying them, it must in general be willing to suffer the matching pain of an interruption in its revenue earning operations. Why then should there be any exception to the prohibition? And this is quite an important question, Why do we actually have this issue of applying for replacement or using replacement labor? Because if in a strike, the employees are withholding the labor in the first place, why have the exception at all? Okay, the obvious answer is that if the employees are in any event on a strike, the employer should not, by responding with a lockout, be deprived of the right it would otherwise have had to use replacement labor during the strike. That justification for the exception ceases when the employees are no longer busy or participating in the strike. An employer who decides to persist with an exclusion of employees from the workplace after they have ended their strike and tendered their services is no longer responding to a strike, but is choosing to use the lockout offensively in a way that is indistinguishable from the employer who, in the complete absence of a strike, embarks on a lockout to compel compliance with a demand. To say that the ongoing lockout is still responding to the strike is to treat the ongoing lockout almost as some form of punishment because the employees chose to embark on a protected strike. The lawmaker could not have intended to reward retribution of this kind. So basically the court is saying that for you to use replacement labor in a lockout, that lockout must be in a response to a strike while the strike is actually still in occurrence. But yeah, I suppose at the end of the day, what do we learn from this? Or I suppose it's not so much really. The question still is then, what is the use of section 76(1)(b? Because in the way I see it, if in a strike, employees are withholding their labor, and you call a parallel defensive lockout as an example, the employees are already withholding their labor, and they're not getting remunerated for it. But the moment the strike ceases, the lockout must cease. Otherwise, there will be an inequitable distribution of power or a power balance in this whole collective bargaining process. And if the employer are allowed to continue using replacement labor, the lockout will become like a form of punishment and no longer serve the intended purpose. But yeah, so in my view, section 76(1)(b probably a bit pointless. The fact of the matter is, in terms of the Constitutional Court now, a lockout, if you want to use, or an employer want to use replacement labor, can only be called while the strike is still in occurrence, and not after the effect of when the strike ended or suspended, I should put it this way. The fact of the matter is, there's no longer a withholding of labor, so you don't call a lockout once the strike ceded and then still try to use replacement labor. That doesn't mean you cannot use a lockout as a tool in this collective bargaining process. It just means that if there's no strike, you can't use replacement labor, and that you will also suffer some margin of pain in terms of no longer having your operations running while the staff are being locked out and not getting paid for that. So that is for this week. I think it is quite a telling court case here in dealing with the lockouts, especially when using replacement labor, lockouts as a response to a strike action from the employee's side. But yeah, I think the days of using a lockout and using replacement labor just after a suspension of a strike, I suppose those days are over, eh? But anyway, till next time, bye bye.